Thank you for participating in the NIA and NHLBI Entrepreneur Workshop Series. This workshop covers the topic of value propositions and differentiation. This breakout room, moderated by Gautam Prakash, discusses the topic of IP strategy as a differentiator.
I'm Gautam Prakash. Thank you for joining the room, and we are fortunate to have Dr. Todd Dodd here, under whose auspices the whole webinar series and this breakout rooms and a whole bunch of other things are. So thank you for joining us, Todd. Todd is the Todd. I'm not going to tell you exact title because frankly I don't know what it is, but he's the head honcho of the small business office at the National Institute on Aging. So Todd, why don't you tell us exactly what you do for us?
If only I knew. No, thank you everyone for joining. I manage the small business training and career development programs at NIA. But happy to be here and happy you all attended the webinar. So I'll just help moderate the conversation today. Gautam, I think you have some initial questions. Maybe you want to get started with, and then we really want to make this as collegial and dynamic as possible. So we encourage everyone to jump in with your questions. You can just let us know when you have a question, raise hand or whatever, and we'd be happy to just take verbal questions.
Absolutely. Thank you, Todd. So I'm going to actually, for one of the questions that came in, I'm actually going to refer you to a previous seminar that Todd helped manage, which is the question was, how do SBIR companies leverage intellectual property protection when working with academic institutions who try and get a majority share? So this is an issue that a lot of companies are very interested and perhaps irritated by. And in one of the earliest seminars, Dawn, who's actually one of our experts in this seminar, who has worked for a university and understands how to negotiate licenses and has a bunch of excellent tips on how to negotiate the university, what their expectations are, what your expectations are, and how to manage them. So I would encourage you to go there because I think that that's an important, rather than me giving you some facile advice, that you might want to go and view the entire thing in its entirety. And if questions arise, then certainly direct them through Todd's office. So let's see, other questions come in. So let me take a few. From Ms. Sanders, in the past, we've done copyright and trademark in-house, but I'm thinking we should probably look for intellectual property paralegal just to speed up the process. So Ms. Sanders, is that a question or you want my suggestion on it?
Let's see if it's letting me talk. I was going to share my video. It won't start video, but it is a question. I love your opinion on that. Will it go faster? There's a lot of steps, just the timeline and back and forth, back and forth.
So, yep, understood. Here's what I'll say. I think a lot of it depends on the volume that you're doing. So, if you're, for example, Coca-Cola, they're filing hundreds of trademarks a day, right? So for them, they can't have people doing it on their side. So I would ask you whether, if you're doing a lot of these repeated filings, and frankly, the fact that you're asking means that you're doing a lot of them, which is nice. Certainly somebody who really knows how the process works is a valuable person to have. Patent secretaries, I'll give you as an example, making the six figures, because it's, as you probably found out, it's a complicated and perhaps unnecessarily complicated and kind of rules-driven process. So I would say to you that a good patent secretary, and in your case, a trademark person, might well be worth his or her weight in gold, because it can be a great help to understand what the forms are, how to fill them out, and get things moving.
Very good. Thank you for your answer.
Sure, and it all comes down to money, Ms. Sanders. So, if you don't have the money, you're stuck with what you got. So it always comes down to money. Great. So Mr. Patel, you're unmuted. Would you like to ask a question? I'll take that as a no.
Sorry, Gautam, apologies.
No problem. Okay, so this is a nice way for us to get into the other two out of the other three lesser known aspects of intellectual property. And when we talk about, there's a whole webinar and a series on intellectual property, and I would strongly encourage you to look at that one as well through the NIA and Todd. But what I'll say here is the focus of this one is to use it as a differentiator and a value proposition. And for those, I really like the way John did it, because what he's talking about is, how do you stand out in a crowd? And most of us, as I said in my introduction, you're not going to talk about your patents when you're advertising. It's all about trademarks, slogans, and look and feel of devices. So that is really, or a jingle. So that's all copyright and trademark, right? For much more than it is patent and trade secret. Not that the other two are not important, but if you're trying to stand out in a crowded field, and one of the questions was, how do you stand out in a crowded field? Listen, it's not easy. So, in any of those crowded areas, you have to ask yourself, why are people coming to me? I have a product, glass of water, versus Coca-Cola selling a glass of water, right? So you have to ask, what is it that makes people come to me and versus somebody else? And part of that is advertising, but that advertising needs to be backed up by some level of protection that you have. In other words, what do you have that somebody else doesn't have? And it certainly can be a nice jingle or a nice slogan. And we can think of several. I mean, Coca-Cola has built a multi-billion-dollar company essentially on trademarks, right? And one very important trade secret, maybe the most important trade secret around. And they built a whole empire based on that. So it can be done. It's not that they eschew patents, design patents, and all these other things, but clearly their business is about selling and trademarks, jingles, slogans, packaging. That's also another way to think about it. And trade secrets are critical to them. If you're driving through a snowstorm and you see two yellow, curly-looking M-shaped symbols, you know where you're going, right? You know that's McDonald's. They take a lot of time in designing their restaurants to look a certain way. And in our intellectual property terms, the word that we use is trade dress. So they make it look and feel a certain way because even from a distance, they want you to come here, right? Look for the golden arches, they tell us. So these sorts of things are important for you to think about when you are thinking about how am I going to distinguish my product or service in a crowded market. In some cases, if it's a new chemical compound, which some of you may be developing, patents are probably the best way to do it. And I will argue that if you don't have a patent on a new chemical entity, you've got problems. You should go get that. But it doesn't mean that you can't think about how would you sell this product, because somebody's got to buy it, right? They're not going to ask for that product by patent number. They want aspirin or ibuprofen or whatever the compounds are. And you see some really, for those of us who've been unfortunately bombarded with various kinds of ads, you see these various pretty strange names that for new drugs, and they're trying to get you to ask for that, right? So again, trademarks. So I would have you think about those sorts of things as well. So remember, strategy, IP strategy is what parts do we want to protect of our invention? So if it's a device, I would say to you, not only do you need a what we call the utility patent on the way things are built and how they come together, but you may want to think about a design patent. And I'm going to hold up probably one of the more famous ones, right? Everybody knows what this is because just the look and feel of that device, you're like, that's an iPhone, I'm done, right? And Apple has a lot of patents on iPhones. The way it looks, the curved edges, the way the button is positioned, all of that stuff is all protected by design patents. And if you're selling a device, you should think about design patents. Those are kind of important, and they can be relatively easy to get. And serve as another form of differentiator for you. I had a question about intellectual property on botanical products. So if it's a formulation, you can get what we call a utility patent on it. I am thinking that it's not a plant, because if it's a plant, we have such things as plant patents. And it's a little more obscure area of patenting, but if you've grown a new kind of plant and there's a huge market for plants, you could certainly get a plant patent on that. But if it's a product from a plant or some plant-based product, the formulation can be protected by what we call a utility patent. Now, if it's just an extract, it's going to be a little harder. If it's a product of nature, you're going to have a very hard time getting a patent on it. But if it's a product of nature, like coumarin or something from the turmeric plant, mixed in with other kinds of excipients, you could certainly try and protect that as a formulation. You may want to protect that as a trade secret, to be perfectly honest. And if it's used for treating something, then you could certainly get method patents. And what I mean by that is patents that have method claims to it, a method of treating, skin cancer, or I should say skin cancer, skin lesion by administering a composition comprising, something like that. You could certainly look into that as well. So, you know what, I'm going to stop here for a minute. We have plenty more questions, but let me give the people who have taken the time to come here, and I appreciate you taking the time to come in, to ask any questions that you might have in real time. Please unmute yourself, or you're welcome to type it into the chat. Todd and Melissa are monitoring both. Or raise your hand. Okay. Time. Perfectly happy to think about, and you have some time. So I have a question here. When is the best time to file a patent to maximize its chances of commercial success? This is a very difficult question to answer. I'll do my best. A concern often is burning up an inordinate amount of patent life during the, yes, agree. So for those of you, to give a little bit of background on this question, a patent term is 20 years from the first filing date. So you can always, you're always playing this trade-off of how early do I file, and there are benefits to filing early, versus the earlier you file, you're using up some of your 20-year clock. So what I would say to you, Prasad, is that you know the field best. If it's a crowded field and there's a lot of innovation going on in that field, you're probably better off filing early rather than late, because you need to get in and you can't enforce a patent that hasn't been granted. But if it's a field where you're the expert, right? I don't know. If it's a field where you think that there may be a less innovation going on, you may want to wait a little bit longer to get your product in better shape. Now, what I would say to you is that the claims of your product, claims on your patent application should match what you think your commercial product is likely to look like. I say likely because it's fairly early in the game, and so you may not know what the product will look like or service. But again, you're the expert. If you can speculate on the shape it's going to take, I would say you probably want to file when you have that concept more firm, because then you can write better claims, and you will know when you get a claim that you're happy to move along with, right? Because you won't fight for things that are not in your space. And I see this a lot, where what people do is they'll be arguing with the patent office about this or that issue. Come to find out, it's not even in the product that they're trying to commercialize. And it's may never be in the product they're trying to commercialize, not even now or later. And you think, why have you wasted this much time to get something that you're going to hang on the wall and just for looks? So I wouldn't do that. So you need to figure out as you trade off. And I would say for the most part, there are very few patents that are valuable till their last day. A lot of drug patents come to mind. So if you're doing a therapeutic, I would say to you, you really got to think about that. And you get time back for delays for the FDA and so on. So every day matters to some of these big companies as they're making $1 million+ a day, a blockbuster drug. But by and large, I would say to you that most patents don't make any money. And they certainly don't make any money, much money on the last few days that they're worth. So if you were to say to me, Prasad, you got two choices, pick one, I would err on the side of earlier at the expense of giving up term at the back end versus filing later and then getting those days, which I never use. And how do I know this? The patent office asks you to pay for 3 maintenance fees. So once you get the patent, you got to pay to maintain the patent. They are at 3.5, 7.5, and 11.5 years after issue. If you look at the statistics, and I think you can find this from the patent office's data website, you can find it somewhere. A lot of people don't even pay the 3.5, if you can believe that, because even by the time it's issued, it's not even worth paying to maintain it. As you can well imagine, 3.5, a lot of people will pay the maintenance fee. 7.5, I think it drops by a considerable amount. By the time you get to 11.5 years after the patent is issued, you don't get a lot of people paying that amount. So that is my one source, which should say to you, earlier rather than later is better. Hopefully it answers a long way to answer the question, so I hope it helps you in that. Srinath Patel, can you discuss the basics of what the Dole Act is? So, and here I will actually, get Todd's input as well. So here the general concept was that before the Dole Act passed, the universities would hire people like they do even today, including companies like an institution like the NIH, and they would pay them. But any intellectual property generated would be the property of the university or the institutions, and not the PIs or the researchers couldn't have access to it. It was difficult to get it. There was no mechanism by which it could be transferred. What the Dole Act did was it allowed for the intellectual property to be transferred from institutions like the NIH, which is the funder, to the universities, and give them the first right to be able to use it to commercialize. Would that be a reasonable synopsis, Todd, of what the Dole, without getting into all the details, but would that be fair, Todd? Todd, you're on mute.
Yeah, I mean, as it pertains to SBR, the key is the Dole does provide you a lot of abilities and protection around invention. And, there are some rights to the government as part of the Dole Act, but reality is many of those rights have never been exercised. So I think, the important things for you to think about when as it pertains to SBR is you do need to, as a recipient of federal funding and part of the Dole, you need to disclose any plans to, any inventions and any plans to protect such inventions. So you want to make sure that you're doing that as part of your reporting. Any IP, will belong to the university. You would have to license it from the university. The government, as a funder of the technology development, though, the important part is that the government is not the IP holder. So just because we're funding your work, it doesn't mean that we own the IP. You and your employer would be the ones that would own the IP and be able to file for a patent. So that's an important distinguishing factor. So you don't have to, when you're getting funded by the government, you don't have to worry about the government them owning the IP.
Yep. Thank you, Todd. And for specific questions on how to satisfy your reporting requirements, I would strongly recommend that you talk to your program officer. So do not just cowboy this. This is very important, and institutions take this stuff seriously. So please do talk to your program officer at the funding institution to make sure that you have satisfied your Dole requirements. John, how can you describe an effective IP strategy to protect methodologies used in software development that are designed to create a unique end user experience? Okay, software patents is another question that came up with it. Thank you, Todd, for answering that previous one. Software, it's a minefield. That the problem is that the law is still in flux, I would say. I would argue for most of us that software patents may not be, again, we're not Apple, we're not IBM and Samsung. Software patents may not be worth the effort that one goes through. But in general, I would say if you're talking about methodologies used in the software development. So, John, are you asking about whether these are protocols that you've used to create the software or protocols that execute the software?
No, I'm actually asking more about strategies that we're using that create a very special end user experience. So our company is developing software for music therapy.
Okay.
And we've sort of developed a strategy that combines a couple of different elements in a very unique way that we haven't seen with other software out there. And I'm wondering what might be the best way to protect the sort of final product, which is the end user experience.
Understood.
Not necessarily like the code itself, but more like the end user experience. Yep,
got it. Thank you, John. That's a difficult question, but so I would tend more towards, again, talking about look and feel and the way the thing operates. That is more in the realm of trademarks and like design, right? So you can certainly and copyright. You can certainly protect screenshots and the way an app looks by copyright. Apple, I'll use it as a very good example, does have a lot of design patents on the way things look. So I would say to you that the areas that I would concentrate more on are trademarks, copyright, and now we're going to talk about trades and design patents for the way things look, but I would talk about trade secret because, John, what you and your team have done, it creates something that you've got control over, which is how is this done? The question here about trade secret, if there are things that cannot easily be reverse engineered, because as you said, you've looked around and you haven't found it, you may want to think about using trade secret protection as a way to protect the underlying, the way you get from not the code itself, but the way the thing looks. And so that might be another way where you're protecting your ideas that translate into the final user experience, and the way it looks certainly can be copyrighted, and you have design patents and you have other, the way the app looks and so on can protect by that. Todd, do you have a comment on this one?
No, I think maybe to transition to the next question is right on this topic. You might have missed it. How do you keep and protect a trade secret in an STL grant where one or more academic institutes are involved? I'll let you start, but then I can add about just IP in terms of grant applications after.
John, why don't you go ahead? Let me think about this for a minute. But thank you, John. Todd. And thank you, Todd, for pointing that out to me.
Sure. So I'll let Gautam talk about trade secrets specifically, but in terms of IP and applications, it is a balancing act. And we have these discussions all the time. And of course, my final advice is going to be to consult your company's lawyer. As we did not, as federal staff, provide legal advice, but providing overarching general guidance. A couple of things to remember: the reviewers do sign confidentiality agreements. Is it the same confidentiality agreement that your lawyer might be happy with them signing? I don't know, maybe not, depending how specific your lawyer is. But they do sign confidentiality agreements. Of course, we all hear in the news when there is some sort of theft of IP from grant applications. But, the fact that we hear it in the news shows how rare it actually is. So, you hear about those crazy stories, but you don't hear about the, thousands, many thousands of applications where none of that ever happens. So it's not, but I understand. I understand you are worried about protecting, but I will say that, generally it's extremely rare that we see any instances. On the flip side, you need to put enough in your application for the reviewers to be able to provide a great score. So, for example, for a drug company, we've had, people developing a drug for a target that no one's been able to successfully develop a drug against. And they're like, well, we have a whole new structure that is going to be much better, but then they don't want to show the structure. And when they don't show the structure, there's no way for the reviewers to know that their structure is actually any better than the hundreds of failed drugs out there trying to address that target. So, it is that balancing act that you do need to consider in terms of what becomes public. The abstract of your application, it does become public if it gets funded. The specific aims page, however, does not. So, just in that abstract, which is really not used by reviewers as a score driving page, that's where you should be very general. But in your specific aims and your research strategy, you can be more specific. There are sometimes questions about, sorry, I'm forgetting the term. But essentially, because it's public documents, FOIA, thank you. The public, someone can essentially what's called FOIA, Freedom of Information Act, request access to an application. It happens very rarely. They have to have a justifiable reason to do so. But if it ever is done for a funded award, we would provide a chance to redact any information that is proprietary. So, you don't have to worry about your application ever just being made public without your approval. You would be given a chance. So that's just some general thoughts there. Gautam, I'll let you maybe build on that and go in the specific direction of trade secrets.
Yeah, thanks, Todd. So,
Todd, I had a question. I had a follow-up question on that. Do you have to declare what information is proprietary ahead of time?
No, we'll have that conversation if it ever gets FOIA'd. So you don't have to declare that. Just make sure that in your abstract you don't put anything proprietary, because that does get released without you approving it. If you get awarded, it automatically gets released into the report database. So they don't go to you and ask you to redact. So just make sure that one abstract as part of your application doesn't have any of that proprietary information.
Yep, it's fantastic. So I'll follow up with something that Todd said. I agree with everything that he said, and you need to give enough to the reviewers. I've been a reviewer and I get applications where I think I don't even know what they're talking about. And in the example that Todd gave with not disclosing the structure, that is just silly, because at that point you're not going to get funded. And if you have a new novel chemical entity, you're going to have to file a patent application on that anyway. Protecting that as a trade secret is a huge mistake. A specific formulation is a different issue. And I've seen applications where they say, here is our compound, we're protecting it by patent, and the specific formulation, excipients, and so on, that we're protecting as or even the excipient itself is a trade secret. No problem. That actually shows me that they've thought through how they want to do certain things, and they're using different forms of IP for different purposes. It warms my heart. It's great. So when you I'll take everything that Todd said to heart. It's important. But when you do think about what should be trade secreted, think about whether that is the mechanism by which you want to protect it. And if it is, it's okay to say that openly that this is what we're protecting as trade secret. Don't put it in the abstract, obviously. And then, but give you the reviewers enough to understand what they're actually funding to help you get the funding. Otherwise, the whole point becomes academic. Okay, I'm going to go through a few more of these that I've had here. So how do startups develop their own IP with limited resources, with difficulty? It's again, a lot of this, I think, unfortunately, comes down to money. And I said that to Ms. Sanders, it's all money. And what actually does help, which you can do kind of for free, I suppose. There are plenty of resources out there. I would not file a patent application by yourself. I probably wouldn't file a trademark application by yourself. It can get awfully complicated. Copyright's a lot easier. Trade secret, you think it's just a question of protecting a trade secret, which it is, but it's important to get the right confidentiality agreements from people who know how to write, non-disclosure agreements and so on. But what you can do for free or on the cheaper is figure out what aspects you do and don't want to protect. And there's so much out there on the web. And what you can do is you can decide, because you've done your own education, about which pieces are protected by what, trade secret, trademark, copyright, design patents, plant patents, and so on. So if you think that through and you have a strategy and it's thought through, and you take that, even if it's half-baked, to somebody, an intellectual property attorney, and you have your ideas on how things are done, that's fantastic. Rather than just saying, I don't know what I'm doing, just to do what you think is right. Well, that's going to cost you a lot of money. So I would say you can do a lot of the stuff up front if you think it through a little more carefully, and hopefully that'll help you a little bit. Let's see, Ms. Panzer.
I was going to add.
Todd, go ahead.
I was going to add one thing to that, which is when I hear to specifically talk about SBR applications, but since it's relevant to that question, I'll go ahead. The Taba Funds, I'm not sure how many of you know what Taba Funds mean, but per the last congressional reauthorization of the SBR program, Congress gave the authority for applicants to request money as part of the application on top of the budget limit, actually, for technical and business assistance. And in phase one, it's not much. It's only like $8,000. And we were able to put together a program at the NIH that, takes that 8,000, probably provides you a lot more than 8,000 worth of value. And that's the needs assessment program. But for phase two, it's $50,000. So in a phase two application, you can request up to $50,000 of technical and business assistance on top of your regular SBIR budget. And one of the things that can be used for is for hiring IP lawyers and consultants to develop IP strategy, to file IP, things like that. I think you can't technically pay the filing fees themselves, but the filing fees themselves, as you've heard, is not the major cost. It's the preparation that goes into the filing. And that's what can be paid with the Taba fee. So that's just something to think about. If you're submitting a phase two application or a fast track or direct to phase two, you can, request that $50,000 and include IP as one of the things that you get spent on.
Thank you. Monique, I think you have something to add. We have the wonderful Monique Leroux here.
Good. We're going to put some more information about that in the chat. I think Todd covered it very well.
So I have a question for Ms. Panzer. So how do you put a value on patent protection? Well, see, again, that depends on the technology, right? So some areas, patents really are the only game in town. Certainly if you're doing a therapeutic, you can make a lot of money enforcing patents. In others, they aren't. So, it's as valuable as somebody's willing to pay for it. At the end of the day, that's all that it comes down to. So you'd have to think about, and the costs, as Todd correctly pointed out, are not in are not borne by the USPTO. The filing fees and prosecution fees are quite similar. Reasonable. It's the attorney cost that costs a lot of money. And I would say to you that you need to think through whether that's worth it to you, because it could just quickly get out of hand. The more you understand what your product looks like, the commercial version of the product, the more you can decide whether this or that patent or this or that type of IP protection is financially viable for you. Let's see, I have a question here. Sorry, it's not a very satisfactory answer, I'm afraid. Jeff Dalton, a suggestion: speak to understanding international patent application rule strategies when you file a US utility patent and start the clock. For example, Taiwan is not a member of the PCT, so applications are filed within 12 months of US filing. We used to like to do so. We bring international patent attorney to work with our US patent attorney when we're filing a US utility application. Good point. So here the issue is that, and this is something that a comment that I've made in one of my previous webinars, and I'll do it again here. The US is not the only game in town. I know it's difficult when you have limited funds, but to just limit your thing to US is not going, your product or service is not going to be as valuable, especially if you are not the person taking it ultimately to market, right? So if you're looking to partner with a Pfizer or a Merck or one of the big boys, they're not going to be interested if the only thing that you have is international patent protection. So, you don't have international patent, you only have US. Jeff, your point is well taken. You need to be thinking about international patent rights from the beginning. And there is a 12-month clock that starts running from the earliest filing. And at that 12-month point, and the earliest filing could be a provisional patent application, and there's a question about that. The value of provisional patent application is it puts the line in the sand as to where you are starting from. 12 months from that, you need to do something. I mean, you could do nothing, it'll expire, that's fine. But if you choose to do something, one of the things that you should seriously be thinking about is, do I think about international rights? And what that means is that for most countries of the world, it means filing an international patent application. For some countries, and I didn't know that thing about Taiwan, but which is unusual, but certainly true. If it's true, that's wow. A big area, especially for semiconductor and all the rest of these things, is that at the end of the 12 months, you do have the right to enter all these various countries without filing an international patent application. And the priority is based on your US filing. That's the reason why the 12 months matters. So I file today, the 17th of August, 2021. The 16th of August, 2022, I can enter Taiwan, and Taiwan will give me the priority as of today, right? Even though I only entered Taiwan, 364, 5 days later, whatever. It is important to think through international rights and see if they're going to be valuable for you. Jeff says, Argentina, Pakistan, about 20 African nations now signatories to PCT. Yeah, you're absolutely right. And, as is like something like North Korea. I didn't know. I mean, some of them you're like, I don't even care about North Korea, but Taiwan is a big deal. So absolutely, think it through. It's important. Thank you, Jeff. That was a fantastic statement. So international rights do matter, and please do at least have them. And if you choose not to file, but you thought through why you're not filing, that is also okay. At least we should be able to. It shouldn't be a question of omission. Ooh, I forgot, right? It should be, I thought it through, and for these reasons, we've chosen not to. Got it, right? So that will help you when the time comes later to be able to market your invention to other potential partners or even customers. Okay, let's see. Benefit of disclosing proprietary information versus holding on to it as a trade secret. Okay, so this is typically what I would say is this. If something cannot be reverse engineered, again, think formula of Coca-Cola or a proprietary database, you may be better off holding on to it as a trade secret than disclosing it and then having everybody. It's especially for methods and database, it's very difficult to try to prove infringement. So Pepsi-Cola, Coca-Cola, okay, they have different formulas. I mean, how do you prove that they've used the same thing if you've already disclosed it, right? So especially if the taste is slightly different, these things are going to matter. Patent infringement is an extremely expensive business. Proving it, getting damages. You thought patent prosecution was bad, which is the business of getting patents. Enforcing them is a total nightmare. So the cost can be very, very big. And frankly, I will say to you, it's the avenue of the big players. People like us, we're just going to be priced out of that market. It's a tough business to be in. So if it's a chemical formula, absolutely, please protect it by patents. A nice way to do it, and trademarks if you're selling it, to the customer. But a lot of things that are difficult to reverse engineer, it may be good to hold on to it as a trade secret. So let's see. Okay. Snehal, a company wants to help me build my software and then they want to license it. They want rights of first refusal. What does this mean? I thought the right of first refusal applies to things that are in limited supply. Are they basically asking for an exclusive license? Okay, so what they're asking for is before you offer that thing to anybody else, you have to offer it to us first, right? If we say no, and negotiate with us, okay? They're not saying, and maybe depending on how much they are giving you to develop it, they might say a right of first refusal at a particular price. But in general, what they're saying is that they would like to get their hands on it first to see if they want to pursue it or not. And if they choose not to, then you're out ready to go and market it to somebody else. Exclusive versus non-exclusive may or may not be related. It depends on what you've negotiated up front. So the difference there is exclusive means that only you get it, versus I can market it to you license it to you and somebody else. So they could be related, they may not be. So Snehal, I'll let you ask the question. I must have missed something in there.
Yeah, no, thank you for that. I guess I plan to market the software to 100 different hospitals that can potentially use this. So does this mean that each time I'm interested in approaching one of these hospitals, I approach this other company each time? I mean, I guess the right of first refusal doesn't make sense to me in the context that I intend to use my software. I'm planning on selling it to many different hospitals.
Understood. So that depends on what agreement you reach with the software developer. Yeah. So it could be just that. And you might say, well, I'm not signing that. Or it could be, look, you're going to have to come to us first, and we have 30 days to give you an answer. And after those 30 days, thank you. If you don't hear from us or we say no, you're off to do whatever you want to do. So it's difficult for me to answer that question because I don't know what the terms of the right. So it's a right. It's like a right like anything else. Okay. And depending on how narrow or expansive that right is, depends on how much people are willing to pay for it. Right. So if the right is you've got to come to me first, and I've got a year to decide, and even if I say no, you still have to come back to me. Well, that's pretty restrictive, and you got to pay a lot to hold on to that right. On the other hand, if it's look, give me 5 days or give me a week, a work week, whatever it is, and after that you don't ever come back to me, well, that's may not be worth as much. So it really depends on what you have agreed to or plan to agree to. So definitely look at what you're giving away for what you're getting and see if it makes sense to you. So, I'm going to turn this over to Monique. Unfortunately, I have to end this event because I have something else at 4:00. But Monique, maybe you want to talk about other rooms that are going on and if people want to move to them. It's been fantastic, and I thank you all for joining me. So, Monique.
Thank you, Gautam, for all of your time, and we really appreciate it. Again, I want to remind folks too that this is not the only time to have one-on-one meetings with us. You can actually schedule one, and we shared those emails with you. We can resend that again, but we want to continue this conversation. We do have some other breakout rooms that are ongoing. So you can either join the IP strategy as a differentiator. You can also, you can join creating successful go-to-market or the value proposition. So those are ongoing. Actually, I'm seeing one just finished. So we can move you to the other one if you'd like to go. We're probably going to go on for maybe 10 more minutes, but we are about wrapping up. If you're going to leave, I did want to remind you to fill out the feedback form, and also feel free to download the links. We will make this presentation available. We really appreciate all of your time. And I wanted to remind you as well about applying to some of the funding opportunities that are currently available, whether that's the omnibus grants, the contract, as well as the READY funding. And please feel free to fill out that feedback form. Todd, do you have anything else to add?
Yeah, I just, we keep doing these workshop sessions, and always helpful for us to know if we should keep doing them and how to optimize. So just another plug for that feedback form, which Melissa just put in the chat. But then also want to my sincere thanks to Gautam for leading us. We're fortunate to have him. So thank you, and thank you everyone for attending.